So welcome to our asset protection seminar. It's a little bit different than the estate planning. We do still talk about trusts and wills, but this is more focused on separating your assets and keeping them safe than avoiding probate. Why does Bay Legal exist? So I started Bay Legal not to be a traditional law firm, but I built it to be the law firm I would have appreciated having before I went to law school as an entrepreneur. My philosophy on asset protection was really forged through personal lawsuits way several years before I went to law school. I went through a divorce in 2000. It lasted about 2 years. I had purchased a construction company in 2003 and ended up in a lawsuit with the seller. And then I, like many people in the construction industry and real estate industry, had legal issues during the housing crisis. So I'll go into some details about all three of those that kind of structure what we're looking at here. But they provided a strategic view of legal and financial structures. We have a system at Bay Legal. It's a 5-pillar system, but the asset protection and trust estate planning is the first 3 pillars. Building the blueprint for your family legacy, entities, trusts, and corporate compliance is the first pillar. So setting up those structures, setting up your LLCs, your S corporations, your trusts to make sure everything is passed on as you wish. And then there's operating. If you're operating a business, then the protection comes from how you operate. And the legal side of that really comes down to contracts that help you limit the business exposure so that you can limit your personal exposure. Entities are also the integral part to operating businesses, but contracts with agreements with vendors, with clients, with partners, with basically everybody you're doing business with are the key to protecting your business and therefore your personal life. And then our third pillar is our litigation department. Sometimes it's unavoidable. There's bad players and bad actors. So we turn your documentation, and I'm not just talking about the agreements, but a good operating business keeps really good documentation, both financially and in relationship to their contracts, ongoing issues. Documentation is extremely important when it comes to litigation. So our strongest clients in litigation issues, they come to us with accountings, timelines, and other issues that are well documented that make their cases much stronger. Okay, so this workshop is for you if you own a home or other real estate, or if you plan to in the near future. If you hire contractors, vendors, employees, or have customers or clients, if you run a business, a side hustle, or if you simply own real estate, rental properties. And then finally, if you want a real structure, not just LLCs and a trust, but if you want to structure it strategically. Okay, why this particular workshop exists? Structures, when you set up an entity, when you set up a trust, you're not going to know if it's solid until later. They're never challenged, well, rarely challenged when they're first set up. The issues come later when somebody challenges it, when somebody files a lawsuit, or when they approach you and say, you know, there's another child that wants to inherit that we didn't know about. So they always look good up front. It's later when they're challenged that we find out if they're going to stand the test of time or not. Getting an LLC online is not a strategy. It doesn't help you in any way other than having that document. Even if you pay the annual fees and keep the LLC up to state requirements, without proper contracts, a proper operating agreement, if something happens to you or if somebody sues you, those documents are key to what happens with your assets. There are California and federal rules for entities in California. There's also other states that are very common, including Delaware and Wyoming. very common places, and they have their benefits depending on what kind of company you're operating. If you're owning real estate, we really want to stick with California. Otherwise, you're reinvesting in the out-of-state entity, and you're registering that in California. Now you're complicating things. But if you're running a business, there's lots of an operating business. There's lots of other options. Okay, so the workshop structure is to go over templates versus strategy. Templates don't create a legal structure. They're papers and paperwork, but they don't usually stand the lawsuit test. I'll go over some of my legal challenges in the past to kind of explain where these philosophies come from. We'll go more in depth into the 3 pillars that we talked about: the design, operate, and defend not only your business, but your personal assets. And then I always like, in most of my webinars, I like to go through some landmines that are related to real estate and contractors, and then discuss the primary residence, how to protect the most equity in your primary residence, depending on how much equity you have. And then at the end, we'll go through a Q&A session for questions. Okay. Templates give you the illusion of protection. The online LLCs and trusts are often identical templates that thousands or even tens of thousands of people use the same template over and over. Assets are, they rarely account for what assets are actually owned, operated, or exposed in that LLC or corporation. They don't describe how the partnerships to function during operation, and almost as importantly, when something happens to one of the owners. If there's multiple owners, what happens when somebody wants to buy, sell, or gets hurt? What happens to their equity? What are the framework around the buyouts or the inheritance aspects? And then when litigation hits and courts examine those structures, if it's not already documented, it's not something you can just go back and backdate. So courts look at that, especially when they're looking to pierce the corporate veil, when they're looking to get through the company and come towards your personal assets. Okay, I learned a lot about asset protection well before I went to law school, and even more before I became an attorney. I went through a very messy and expensive divorce in 2000 through 2003. We owned a couple companies at that time, and the fact that our documentation did not take into account what would happen, not just to me and my spouse, but our partners and their spouses. We didn't account for anybody having a relationship breakup. And as you can imagine, in most situations where there's a divorce, most of the time people don't want to keep working together. So if you don't account for those things, what ends up happening a lot is the company shuts down and nobody benefits from that equity, or you end up fighting over it and spending more on legal fees than the company's worth. The second thing that happened around the same time the divorce was final was one of the companies that I purchased in 2003. The owner, that's the previous owner who sold it to me, decided to open up a competing company literally in the same construction strip mall. It's 3 doors down, opened up a competing company, and I ended up in suing him for lengthy lawsuit over a non-competition agreement for many years. It really opened my eyes to the fact that with all good intentions, without the proper contracts, you're stuck. And I was stuck. We had already invested the money in the property, in the business, and we couldn't just walk away from it. So we were forced into this long-term lawsuit. We ended up winning a substantial amount of money in the end, but it cost us more than that because he broke the contract in the long run. And then in 2008, in the financial crisis, I had 2 different businesses. One was a construction company and one was a hospitality company. that both shut down due to the change in the environment. Most construction companies in California either went out of business or they struggled for several years after 2008. So I learned that preparation for those instances where your business slows down so much, you still have vendors, you still have customers, and those contracts that you have become key to being able to get out and negotiate your way out of potential lawsuits. And luckily for us, with both companies, we avoided any lawsuits. So our philosophy of engineered excellence is we produce high quality work, but it shouldn't be a byproduct of stress. It should be done beforehand. A lot of things, if done at the last minute, can actually be reversed by the court. If you try to move assets or change ownership after a lawsuit or after one's been threatened, but before it's filed, oftentimes the judge will reverse those transactions to give your opposing party access to your personal assets if you move them too late. So we're looking at moving things before the problems start, and even better to structure it initially when you're first setting things up from the beginning. And as it says, shift from heroics to a predictable infrastructure, so you know if somebody sues you, what are the next steps, what's protected, and what you need to worry about. Okay, back to the 3 pillars of protection. The first one is designing and building. Again, best if it's upfront when you're setting up your company, buying the company, or starting your rental business. If not, it can always be changed. I've had a conversation with a contractor today who does a very, very big business in the pool industry, and still operating under their personal name. They've realized for many years they've got a lot of liability by doing that under their personal name. And we're going through the process not only of structuring their LLC, or actually in their case an S corp, because they were already making a lot more money than an LLC made sense for, and restructuring their contractor's license to be part of the company, restructuring all their contracts to be signed by the managers and not by them individually. And it's a 2 to 3 month process that we're coming to the end of. But if they face another lawsuit from a customer or an employee, they're going to be in a position where the most they're risking is the assets of their construction company, and they don't own any real estate through that construction company. So it's mostly just liquid assets that they can move around. So even if you've gotten yourself down that path, we can start the process of correcting that, as long as the lawsuits haven't already been filed or threatened. Again, operations, what's really important besides the contracts themselves is that you don't sign contracts under your personal name. It's always important to sign as the manager, CEO, president of the company. If you sign with your personal name and your personal name is in the header of the contract, you're personally liable. And then finally, turning the documentation, which means keeping good books, financial books and operations books, into defensive weapons if somebody does come after you, or offensive weapons if somebody doesn't pay you and you have to go after somebody else. A little bit more detail on the first pillar. The core systems are establishing trusts for passing on your assets how you want to your children or other entities, nonprofits, depending on what you want to do. I tell my trust clients that if they can think of it, we can write it up. We can put it in the trust and we can make it happen. There's nothing too complicated to put in a trust, because it's a contract and it's your wishes. So it might take us a while if it's super complicated, but I've had clients with over 30 nonprofits that they wanted their assets spread over once they passed away. So it's complicated and we have to get all the right information, but it's possible. The entities, they hold wealth for holding companies, real estate holding companies, or they operate businesses that create wealth. And again, the trusts help you to avoid probate, and so do entities. Neither of them go through probate as long as in the operating agreement for an LLC or the bylaws for a corporation, we have the terms of what happens when something happens to you. So as long as the terms are drawn out and nobody challenges it, you're gonna stay out of probate court and save those probate fees, which can range from 7% down to about 4% as the value of the estate or asset goes up. And then the goal is to both provide privacy and a seamless transition of assets to the next generation, rather than have it all enter the court system and become very public. This is the ugly slide. When it comes to succession planning, depending on the value of your assets and the structures, we have lots of tools, which I'm not going to go into specifically, but we have lots of tools to help move things on, reduce estate taxes, and help your families to benefit from your work over your lifetime. Pillar 2, the asset operations and deal side of running a business. Real estate and business, when you're handling deals or you're a landlord, the contracts are key. Especially, and it's not just the legal language, it's how they're executed. Again, one of the biggest mistakes business owners make is they sign contracts, or they continue to sign contracts after operating as a sole proprietor under their own name. Their name is in the header. This contract is between Jayson, Elliott, and Octavio, and they sign it in their personal name, even though it's a business-related contract. So making sure that we sign those contracts as the business owner, or even somebody that works for you as a manager, and that we don't commingle funds. Those are two of the biggest issues when it comes to operating businesses. And then maintaining compliance with the state, with the federal government, and with the IRS are obviously extremely important. And then your employment agreements are particularly important in California because of our employment laws. Nowhere else is quite as strict. New York's pretty close, but California employment laws are specifically burdensome, not only to make sure you're compliant, but if something does happen, the penalties are extreme. The third pillar is the defense pillar. It could also be the offense pillar if you're going after somebody who owes you money, somebody who didn't pay on a contract. But that weapon comes from your documentation, your financial documentation, who paid you, who you paid, when, and your operations documentation. If you're in a business that delivers a product, or you deliver things in stages, keeping all that in some kind of a system, even if it's a spreadsheet as you're getting started, is extremely important. Proactive management of construction and HOA related conflicts. If you have construction, whether you're a contractor or you're hiring a contractor, keeping records is extremely important. One of my biggest areas of litigation is construction law, and a lot of things come down to he said, she said, or the values accounting for who owes who money are extremely difficult, because homeowners don't tend to keep really good books when it comes to their personal life when they're dealing with contractors. And contractors tend to even sometimes be worse. They don't keep track. They know how much they're owed in total, but they don't keep track of the payments, and they're going back and trying to recreate their ledgers. So if you're in any business that delivers something on a ongoing basis, like construction progress, keeping your ledgers active and accurate is extremely important. And so the overall strategy is stopping the interference before it costs a sale or triggers a lawsuit, or if you're the one on the offense before the opposing party that you're going after can threaten you or scare you out of proceeding because you've got all the records to show they owe you that money. So going forward, once your strategy is in place and you're operating a successful business, or even if you're employed and you've got a property portfolio you're renting out, whether it's traditionally through Airbnb, we offer proactive annual reviews of your overall structure, asset protection, as well as trust, so that you can watch your businesses and assets grow and update the structure as needed. Usually updates come when equity grows. We don't want to put too much equity, if we can help it, in one basket, because that equity is what people see and encourages lawsuits. One of the first questions I ask every potential client looking to sue somebody else, or if they're being sued, is how much money is there? Because if you're going to spend money on litigation, there better be something at the end to get, or you're just doing it for educational purposes. So keeping assets divided into separate buckets keeps the temptation of going after the different companies or you personally down, and it puts you in the driver's seat. Okay, how to plan with these pillars in mind. Okay, looking at things through a financial lens and thinking like a master of finance, legal structures all have financial infrastructures. They're not just a list of rules. I discussed earlier, the alter ego trap is the easiest way for somebody to get through your company to your personal life. So if you treat your LLC or corporate piggy bank as your piggy bank, you're paying for personal items through your company. It can be as simple as paying for dinners that aren't actually corporate related. But a lot of people, especially once they go from sole proprietor into the corporate structure, they're used to using those bank accounts. They're kind of a quasi personal business bank account, and they're used to using them interchangeably. Once you have these structures, they don't work if you keep doing that. They'll work until somebody sues you, but once somebody sues you and a judge takes a look at your books, you risk them being able to get through that entity into your personal life. Again, I've talked about this because it is a constant that I see, is signing contracts personally does put your personal assets at risk. It puts you in the seat of being responsible for that contract rather than your company. And just generally speaking, risk is not universal. So using these template LLCs or trusts also is not universal. We really have to look at your personal assets. Everybody has a different risk profile based on their job or their business. I told somebody earlier today that my mother was a school teacher. I'm an attorney. I'm much more likely to be sued and am sued from time to time because I'm an attorney, to where my mother has never seen a lawsuit in her life except for a car accident where she got hit and was in a very small lawsuit. So everybody's got a different risk profile, and that risk profile affects everything else we're talking about. What are the chances you're going to be sued in your whatever your profession is, if it's employment or a business?
Just so you know, it looks like your slides are stuck. You're stuck on pillar two. If
Really?
you're not, yeah. So I don't know if you
I'm
want to
not.
restart the share or something.
Yeah. Thank you, Keegan. Did that help? No. Okay. Sorry, everybody. Technical difficulty. Try that. How's that? Do you see ongoing stewardship?
No, it's just black. I can try sharing mine if
Let me try it one more time, and then if not, we'll have you share. Yeah, I can see it gives me the little sharing screen. So it's black. Can you try sharing yours?
yeah, let me do that.
I'll stop sharing. Let me tell you what slide I was on.
Ongoing stewardship, right?
No, it was on the sorry, I got to get out of my presentation mode to tell you. Yeah, so go ahead to the next one, the pillars, and then the first slide after, so 22. I wonder why it does that. Okay, so go, yeah, so we've just finished with that one. We'll go to the next slide. Two more. This is what I was just talking about, the alter ego, signing contracts personally, and risk assessment. Go ahead. And so one example of an individual decision is how long to keep your personal residence as a personal residence in a trust. Whether the residence is in your personal name or in a trust, if it is your primary residence, you live there full time. This doesn't work for second properties, but if it's your primary residence, the living trust, the homestead exemption in California, in most counties in California, it's based on the average home value in your county, but most counties in California are up there in home value. The except homestead exception is about 600,000. And practically speaking, you can bump that up a little bit because if somebody were to sue you and they were to try to foreclose on your house and attempt to sell it, there's going to be fees, realtor fees, and depending on the value of the house, that could jump that 600 up to 7 or so. So you've got about 700,000 protected from a lawsuit with that homestead exemption. Once you go significantly over that, it's your equity becomes a target for potential lawsuits depending on your risk profile. And for some clients, we give up some of the benefits of having a personal residence in order to move it into an LLC and protect the equity in the home, and also to move it to the next generation. There's some tax benefits long term having it in the LLC. There's also some other tax non-benefits by not having the residential benefits. Go ahead. Okay, so I like to bring this up in most of my webinars because it's a common misunderstanding. But the contractor trap, we're talking about contractors for the California State License Board working on your residence. Unlicensed contractors are legally considered your employees in many cases. And I've had cases come to me, usually the contractor, the homeowner comes to me, they've hired an unlicensed contractor. One example that I had was there were 5 gentlemen that were doing a landscape job. The head gentleman gave them a contract. It was written out fairly professionally, but it wasn't on letterhead. And they kept a very good ledger on the contract as each payment was made. So we had a pretty good idea of what was paid when the dispute initially erupted. A few months later, all 5 of them had gone to an employment, not to a public lawyer, but to a firm that helps, like shoot, I can't think of the name of the legal aid. And they sent demand letters to the homeowner for their missed income as employees. And the total between the 5 of them, they were very different, but the total was over $150,000 for a landscaping job that had been quoted as $15,000. And they ended up having to hire an employment lawyer to help defend this action. So I know it can be a lot more expensive to hire licensed contractors in California than unlicensed, but this is not an uncommon story. And there is actually people, unlicensed contractors out there that do this on a regular basis because they've figured it out that they can make quite a bit of money under doing it this way. You become personally liable for their actions. They're not required to have workers' comp insurance, and they definitely don't have liability insurance. So The lack of those insurances really put you as a homeowner in the employer category and in the liability category. So data intelligence as a shield, again, systemizing your records. If you're selling a home, even if it's not for 15 years, keep track of the work you do on the, not you personally, but the work you have done on your home over the years. It's now required that we disclose everything to a buyer that the buyer might find important. Not what we as a seller might find important, but what we as a buyer find important. So disclosing all the work done on a house, whether it was done with permits or without, is extremely important at this point in time. So keeping a ledger on your residence like you would keep on a business property has now become, especially in the last 15 years, extremely important. And once the transaction's done as a buyer, you fulfilled your duty under the contract almost to 100% once you've paid for that house, once you've paid the amount in the agreement. Even if most of it's through a mortgage, you've still fulfilled your duties. The seller's duties last much longer, up to 4 years in most cases, and sometimes longer if something's intentionally hidden. So a seller walking away from a home thinking the transaction is over is no longer the case in California. These laws are also spreading across the country to other states. Washington's getting pretty strong. And so full disclosures are required almost if you want to leave the position and the transaction without being worried about being sued years down the road. Okay, looks like next steps. So we offer a stress test of your current structure, whether you're operating without any entities or trusts, or if you've got a complicated structure already that you've set up yourself or somebody in the past has helped you set up. We will review that. If you schedule an appointment within the next 7 days, we'll include 1 year of what we call stewardship, where a year after we help you set up or restructure a living trust and at least one entity, we'll review them for you free of charge the following year. And this is included with any trust plus entity or multi-entity package. Again, the timing is important. You can't make major changes after you've been sued without a serious risk that a judge will undo the transaction. So putting these things in place when everything's going well and you're not in a lawsuit is the right time.